Okay, we're going to go ahead and get started. If you're just coming in, take your time, grab something to eat, grab something to drink. For those of you who don't know me, my name is Michael Lauderdale, and this is Lauren Hanna. Lauren and I work together for many of you on employment-related matters. I'm going to handle the majority of the talk today, and then Lauren's going to take over in Tulsa. So if you want to see and hear Lauren, I suggest you go to the Tulsa Repeat Performance, which is this Friday. So, as part of our Government Gone Wild, we're going to talk about my favorite subject, the Equal Employment Opportunity Commission, known in some circles affectionately as Satan. Similar to the DOL, the current administration has asked for significant additional funds to the EOC. What do they want to do with those additional significant funds? What do you think? Make your life miserable if they get the opportunity. But seriously, they want to provide more funds for investigation, and most importantly, they want to provide more funds to allow them to file additional lawsuits. Here in Oklahoma City, we do, and I say that jokingly about what I call the EOC, we have, in many instances, in most instances, a pretty good relationship with the investigators, and there are 2 lawyers that are here in Oklahoma City that will take cases. And as you know, when a charge comes in, just as with the DOL audit, we have to pay attention to it. You will get an offer of mediation, and let me give you my little mediation speech right now. Most of the time, we want to go do EEOC mediation. Now, why is that? People will sometimes, our clients will have a harsh reaction to that. Well, why do we want to mediate? We didn't do anything wrong. We're not paying anything. Well, that's true. And as you know, it's very expensive to defend an employment-related lawsuit. And we have been very successful with the EEOC's mediation program in resolving claims for not very much money. Even if you don't resolve the claim, an EEOC mediation gives you a chance to sit down with the charging party and talk to him or her about her claims. You basically get to sit in a very tiny room that's about as big as that table, and you sit across from the charging party, and they will tell you what their claims are. Now, that's a pretty big advantage, because 95% of the time, there's no lawyer present. And you can do those with counsel, without counsel. And I've never walked out of one of those EEOC mediations without learning something new and important, even if we didn't resolve the case. And you basically get to hear the whole story. And we've walked into those at times, and we have heard something completely different than what we thought. And when we do realize we have a problem, because shockingly to all of you HR professionals, there are times when your managers and supervisors maybe do something just a little bit crazy, right? Fortunately for us lawyers and fortunately for HR, I tell all of you that I work with, human resources is great job security. We're all going to make mistakes. And if we find those out in the EEOC mediation, we can settle the case pretty quick, sometimes. And secondly, it buys you some time too. So ask for EEOC mediation most of the time. If you find out that there's a lawyer representing them, you can back out. You're not bound to do it. And so it's a good thing. If you get an EEOC charge and they do not offer mediation, you should be on alert, because it's routine for mediation to be offered. If an investigator flags a case, makes it an A case, and we're going to talk about these systemic investigations, start doing your homework. In all instances, we need to get a litigation hold in place. If you're not doing that, make sure you have a process in place to preserve all information. But if they don't offer mediation, it's usually a concern. I can normally tell 95% of the time when a charge is going to be seriously investigated. So, let's go over a few things. Here's what we see on the charge activity. This is my more money, more money, more money slide. The higher numbers, the better for McAfee and Taft. And you can see the charges going up. I mean, just between 2006 and 2012, we have an additional 24,000 charges that have been filed. We're seeing an uptick here in Oklahoma mainly because when things are really good, no one's really terminating anyone because economy's booming, going great. When things are really bad, you see a lot more layoffs. And when other employees look around and they see other people getting laid off, they don't seem to be isolated about or concerned about that as much. When things are pretty good like they are now, and there are concerns about expenses and we are kind of letting go of the problematic employees, that's when we see an uptick in claims because they're looking around and all their friends are still working and they're not. And so right now we're seeing a lot more charges come across here in this state. This is what we're concerned about, the systemic investigations. And I'm always surprised by the low numbers. Now, when I say systemic, this is when the EEOC flags a charge and normally brings lawyers into the process right at the beginning. And you'll know when you get hit with one of these because the EEOC will move 10 times faster than they normally do. Now, this is different than just what I call a routine investigation, where you file the response to the charge, you get a request back for additional information, they may ask to do some interviews. This is ratcheted up. It's a very detailed request for information. They immediately want to come out and do a site visit, and you're just kind of overwhelmed. And if you see one of these coming, you have to pay attention because the EEOC will not ever walk away from a systemic investigation. Once they start spending the time and effort in pursuing it, they will hang on to it until you either enter into a conciliation agreement, pay the charging party money, and do some training and some other things. Know this, when you see a systemic investigation coming, chances are you're going to get a charge determination. Now, these are the EEOC own statistics, and you'll see that the reasonable cause findings are about at 40%. I think that number's low. I haven't really drilled down. But what you'll also notice is that out of the 240, only 12 lawsuits were filed. And why do you think that is? It's because they all resolve themselves. Once you get into it with the EEOC, you're either going to settle or they will file these systematic claims. What types of claims are they pursuing that they're focusing on? Interestingly, ADA is at the top of the list. There was a focus in the last couple of years on pursuing disability-related claims. As we'll talk about in a second, that's changing. Multiple claims, you'll see all sorts of different, usually it's an ADA claim or a Title VII claim, and then they throw in retaliation. That's just a mix. Retaliation is always up there, as you've heard me say before. Those are the types of claims that worry me the most. Sexual harassment, race. Interestingly, not a lot of pursuit on the age-based claims. Religious discrimination claims are starting to uptick. We'll talk about that a little bit more in a second, but it is not one of the EEOC's focuses for 2013. So what is the EEOC looking at? What do you need to be on the watch for? Because what they'll do is big EEOC and DC will come out with an enforcement plan, and they'll list some priorities, and then they'll drill down and list target areas. And so here are the things that they're telling their local offices to focus on. And when I say focus on, they're basically drilling all the way down to their investigators, and they're saying, if you see some of these things, you need to let the lawyers know, and we want to flag the case. Now, here's just kind of the overview. Protecting migrant, immigrant, and other workers, addressing emerging and developing issues, which we'll talk about in a second, and preserving access to the legal system. Now, what does that preserving access to the legal system mean? What do they not like? If an employee can't get to court and have a jury trial available to him, what does the employer have in place? Arbitration. You heard Sam talk about that earlier. EEOC doesn't like it when employers have arbitration policies. National Labor Relations Board has come out and said, we think that arbitration policies interfere with a worker's right to engage in concerted activity. And there's an opinion that came out from the NLRB that said a class action bar in an arbitration agreement is illegal. Only applies to non-supervisory employees. That case is currently on appeal at the Fifth Circuit. I listened to the oral argument. I'm very confident that the Fifth Circuit is going to kick that case out, as almost all federal district courts that have looked at it have done. I think 3 courts out of 20 have said that's okay. The rest of them have kicked it out. Just as a side note, there's a reason why the EEOC doesn't like arbitration, because it's not good for employees in their opinion. There's a reason why the NLRB doesn't want you to put class action bars in arbitration agreements. It's very critical to do that. If you think about how a class action works, the threat is you got one plaintiff and they bring in all 1,000 of his friends, either in a wage and hour lawsuit or even in a smaller harassment or age lawsuit. But those numbers can get big, because if it's a gender claim like the Duke versus Walmart case that's going on, they're saying every woman applicant and employee is part of that class. Supreme Court said that's not really going to work, but it's out there. In an age case, for example, every employee over 40, we're going to bring in a class. You have an arbitration clause with a class action bar, it is a massive deterrent to the plaintiff's lawyers to bring that. Now, there's pros and cons with arbitration. It's not good for everybody, but the class action bar is a big, big bonus when it comes to deterring claims. Now, the EEOC is not bound by that arbitration clause. So just between us friends and subject to the attorney-client privilege, if you get an EEOC charge, do you start waiving your arbitration agreement in front of the EEOC? Everybody shake their head no, so I make sure I understand. That's bad. Don't do that. They might get a little uppity about that. All right, so with that overview, what are their enforcement areas? They're going to tell you, we're going to really focus on the hiring process. And we'll talk about their key inquiry. And I want to make sure when you leave here today, you guys fix this problem if you have it. They're focusing on compensation discrimination. And then they're coming to tell you that we still see harassment everywhere. And so we're going to focus on harassment. So, hiring. Guess what they're focusing on? Background checks. What kind of background checks? Criminal background checks. They are looking for employers that have a policy that says we will not hire any person that has a felony conviction, period. Now, some of you are thinking, we don't have that policy, but some of you might. And even if your policy says it's not an automatic bar, most employment applications will say conviction of a felony is not necessarily a bar to hiring. You got to drill down further and find out what you're really doing practically. Are your recruiters, are your people that are handling the hiring process automatically chunking applicants that have any sort of criminal conviction that shows up? They're looking for that complete bar, so you need to check that. What they want you to do, and what we advise you to do, is you have to have an individualized assessment. You have to apply it consistently, and here are the 2 key issues you have to look at. First is time. You have to have it has to be proximate in time. You don't want to not hire someone 20 years ago because they had a shoplifting charge. And you have to look at the proximity and make sure that it's reasonably related. And then you have to look at the conviction itself to make sure that the conviction is somehow reasonably related to the job. Now, some convictions are easy. Violent crimes, rape, murder, armed robbery. 99.9% of the time, you can draw a connection to that incident that would cause you concern in the workplace. It's the other stuff where we get into these iffy areas, such as drug-related. How do you deal with a meth conviction that occurred 10 years ago? What about distributing controlled substances, which a lot of times is what nowadays? What are you guys running into that your employees are utilizing in the workplace that causes problems? I'll tell you, since we're big, prescription drugs. So there's a lot of these controlled substance charges that come up. And then you get into all the different, what I kind of call the financial crimes, which are bounced checks, shoplifting, embezzlement, petty theft. Can you draw a connection? Sometimes it's easy. You're a bank. Any financial related crime is a red flag. You're going to be able to bounce that. You're not a bank or you're not in the financial industry. What do? Well, if it's an accounting position, that makes it pretty easy. But what if you're talking about a runner or a courier or your receptionist? How do you draw it? All the EEOC is looking for is to make sure that you are doing that sort of analysis. They are looking for those of you that just have the blanket exclusion. And when they get a flag, when they get a charge that someone wasn't hired because of a criminal background check, they're going to flag it and they're going to drill down. And you want to be prepared for that in case it comes up, because they'll pull that from mediation and you will get deeply investigated. Another big area is compensation discrimination. And they are looking at disparate impact, compensation issues, mainly dealing with gender. And they are flagging equal pay cases where a woman employee comes in and says, I'm doing the same thing as A, B, C, and D, and I'm getting paid less money. They are flagging those. And when those get flagged, they're going to start asking you questions. The area where I see this coming up a lot is in hiring. And what is happening is, in certain positions, it's a pretty tough job market. And we're competing for employees. And so in order to get employees to come to work for us or to draw them away from another employee, what are you having to do? Got to pay them more money, right? Throw more money at them, bring them in. Well, when you have what I call multiple positions and your average pay for the position is $40,000 and you're bringing in a new employee and having to pay him or her $50,000, we all know what kind of problems that causes, right? We have to deal with that, and it can be economic issues, but we're all having to go through that. Well, this is leading to EEOC charges, because here's how it plays out. Normally, you bring in an employee that's under 40, in many instances a male employee, and to get him to come in, you've got to pay him more than the rest of your employees. Now, how do your female employees and those employees over 40 that have been there a long time feel about that? Not happy. And you get an EEOC charge, and it's getting flagged. Now, how do we defend against that? Or in other instances, we've got a superstar, and we have to pay that person more money. He or she is knocking it out, doing a great job, and we're just saying, you're doing better than everybody else, we're going to pay you more money. And that person may be younger, that person may be a different gender, that person may have less seniority, and we have a pay discrepancy. So when the EEOC comes calling, how do we deal with that? Well, the market issue is easy. We talk about the market defense, and I've had some success with that, but they still they don't like it. But make sure when you bring in someone that's out of your salary range that you document why in the file. The other way to do it is the obvious way. When we're promoting or paying someone more, we have to have consistent employment evaluations. And when you call me and say, I'd like to terminate John, one of the things I'm going to ask you is, need John's employment evaluations, I need to see John's raise and salary history, has John gotten a bonus, And you deal with the same thing I deal with, because you're not really looking at the employment evaluations and you get those back. What do they show? Has John been an average employee? If we're lucky, most of the time John's been above average. But we don't count that, or our people don't count that as bad, because everybody wants to be excellent. No one wants just to be average or above average. But in a lawsuit, that doesn't matter. And so if you start seeing these pay discrepancies in similar type positions, make sure our employment evaluations back it up. Because if I get the EOC charge and Jennifer is saying that John is being overpaid, and I can go back to the EOC and say, well, John's being overpaid because here. And I can drop the employment evaluations in front of them and say, he's a 10 out of a 10, he's done this, he's done that, and we'll be okay. We'll win that case. It's when John and Jennifer's employment evaluations kind of look the same that we run into a problem, or there's nothing in John's evaluation or Jennifer that distinguish the two. If you are doing this, you're making exceptions to minimum qualifications, if you're making exceptions to your compensation guidelines, again, make sure our performance evaluations are up to par. It's easy for me to sit up here and preach you to be consistent, and I know that you don't have complete control of this in many instances, but we have to drill into our managers and supervisors' heads. They've got to take time to do their evaluation. They've got to use words, and they have to be honest. I know, easier said than done. At the last area, harassment, anti-discrimination. 1/3 of all suits filed by the EOC in 2012 are harassment-based claims. EEOC is coming right out and telling us they're targeting harassment because they keep seeing the complaints. What you're not seeing is a lot of sexual harassment complaints. You know, if you've heard me talk before, we're not seeing those because of two things. One, almost throughout the workforce, everybody understands what the rules are in regard to sexual harassment. And so we don't see a lot of that because people know they have to be careful. And that's been through education and training and everything else. We also aren't seeing it because the public is just not as sensitive to it anymore as they used to be. The plaintiff's lawyers know that they're not going to bring a claim because a few jokes were told, because someone asked someone on a date, someone made comments. Jurors are desensitized to that, and so are courts, so we're not seeing a lot of that. This last issue is, in my opinion, something that's going to play out over the next couple of years. And what the EOC is saying is that this is an emerging issue for us, and we're going to make sure that gay, lesbian, bisexual, and transgender individuals are free from discrimination. And even though Title VII doesn't address that, and even though courts have said in and of itself this isn't a category that's subject to protection, we all know the courts have also said that if sexual harassment involved, we're going to tie that back in. And in Oklahoma, we're a little bit sheltered from a lot of this, but it's out there, and chances are you will run into it. And there's all sorts of ways it can come up. Dealing with dress, use of bathrooms, you name it, it's out there. And so be on the lookout for that. And if you run into one of those issues in the workplace, just be very aware that we need to document and cover everything, because if something does go wrong and you draw the EEOC charge, EEOC is going to flag it. So I got done early, which is shocking. But Charlie Plum is coming, and I can assure you that he will use any of the 40 seconds I have left, as well as Roberta Fields. And they're going to talk about independent contractors. Thank you.
And so we have to figure out where we can stand, since both of us are apt to move around.
And now's a good time to warn everybody. Roberta and I are both from Ohio, so we're both hyper. We're going to be pacing a lot. Neither of us is going to sit down. We'll probably interrupt one another. We're from Ohio. We're not good people, okay? So just live with that, okay? We're the last session before we break for lunch, and the afternoon, as Paul told you, is devoted to employee benefits, the new health care laws and the new retirement laws. So we hope you'll come back and see those sessions. We've intentionally kind of separated it so people could make choices, and hopefully you'll go to both the morning and afternoon sessions. If you've already signed in, please don't worry about signing back in when you come in the afternoon. We're going to have some new attendees, and probably some of you will leave, but if you've already signed in, you don't have to sign in the afternoon. So with that, let's start with our issue of misclassifying independent contractors. And this is a hot-button issue. It's a hot-button issue for both state and federal employment agencies. It is a moneymaker for government, right? I mean, if they contend you as an employer are misclassifying individuals as independent contractors when you should really be treating them as employees, you owe them some money, right? Okay, so what we want to talk about today in our session, Roberta and I, we want to talk a little bit about why and how this has become an area of increased scrutiny. The governmental agencies that handle employment issues, whether they are federal or Oklahoma, have been very outspoken that they're going to be digging into employers' workplaces and see if you've misclassified individuals. So we want to talk about that. We don't care what you call them. Doesn't matter if you want to call them contract employees, advisors, Yoda, consultants. Temps, doesn't matter. The Ohioan, I was rolling, and she just goes right in there, okay? It doesn't matter what you call them, doesn't matter how you pay them. We're going to cover the kind of considerations you need to take into account to see if you're using people you classify as independent contractors, and they may be treated as an employee by other agencies. We want to talk about the pitfalls involved if you are misclassifying, because again, our effort today is to be on the preventative side. We want to arm you with information and tools so you don't get in trouble. So we want to show you the pitfalls, the standards to use and consider, and then suggest an audit, a way in which to be proactive. Roberta's going to cover to kind of bring all this information together and give you some practical ways to see if you do have a problem. So let's start with, why do people use independent contractors or use individuals they call independent contractors? This will help you to see if you perhaps have some of these issues in your own workplace. You may use individuals you classify as independent contractors because you don't have on staff particular skills. You have a specific project or issue you're dealing with, and nobody that you've employed has the skills to handle that, so you bring in an outsider, hopefully on a temporary basis, to solve that problem. A lot of times when we have some economic uncertainty, as we've had over the last several years, employers may not want to take the risk of bringing on permanent, don't use that word, okay? Permanent employees, use the word regular employees, and the way they put their toe in the water to see if the economy is going to pick up and their business is going to stay steady is they start using people they call contractors or independent contractors. And then if things go steady, things go well, business continues to do well, then they convert them into employees. One day they're a contractor, the next day they're an employee. Independent contractors are used by employers to avoid expenses. I can shift workers' compensation liability. I don't have to face unemployment claims. When I terminate an independent contractor, I'm not liable for overtime. All those sorts of issues are reasons employers tell us, hey, this individual is an independent contractor. I'm not treating him or her as an employee.
So having said there are good reasons for this, we don't want to understate the fact that the government takes issue with this, if in fact these people should have been deemed your employees, because the government's not getting its money. I read an article in the Wall Street that said the states have started looking at this more seriously back when the recession started, because they saw it as a way to get more money. You get more taxes, you get another employer to contribute to the unemployment fund. So there's real revenue here, and so the federal government and the state government has a big interest in this. I think the Department of Labor also, if you want to give the benefit of the doubt, also cares about employees, because these independent contractors, or whatever you call them, are generally not covered by your retirement plan. They don't get benefits, and so they could be potentially working side by side for 5 years, 10 years along someone who is an employee and who's getting the benefits, and there is an unfairness to that, which is how this issue often comes up. So what are the tests? Well, courts use different tests, agencies use different tests, and there are lawsuits all over the map. I think it's really a function of control. Is this employee in business for themselves? Like, a good example would be if you owned a building and you hired someone to paint that building. Well, they likely would tell you when they could do it. They're going to make a profit on it. They would bring their own supplies to paint the building, and so I think everybody would agree that's an independent contractor. On the other extreme would be, let's say you're running a business that has a call center and you have 30 employees who work in the call center, and 10 of those are not employed by your company, they're temps, and 20 are. Well, they're all doing exactly the same thing. They're answering the phone that you provide. They're required to come to work when you tell them to. They all receive training from you about how to do their job. And so it's difficult to distinguish, and I think the government wouldn't. That's not to say you can't have these people for a brief period of time. As Charlie indicated, there are business reasons. Companies aren't sure if they're going to expand, if the expansion is going to be permanent. There are good reasons why you do this. The cases are all over the map, though. I read, there was an article in the Wall Street on March 4th that talked about FedEx workers. FedEx for years has tried to say that their drivers are actually independent contractors, somewhat successfully, to my surprise, in the courts. They settled a California lawsuit in 2008 for $26.8 million, and then they changed their structure just a bit. So there's some real liability here. Another case that was mentioned in the article was, I hesitate to do this with Charlie up here, but it was exotic dancers sued a...
Exotic dancers are people too, Roberta, okay?
Sued a casino saying that in fact they should be employees and not independent contractors. And the issue was they furnished their own costumes and their own makeup, but they argued that the employer told them what they could and couldn't do and when they had to show up. I think that probably would have been a loser, to be honest, but it settled, so we'll never know. It settled for $12.9 million. So these are expensive issues and not to be ignored. So we've given you the IRS test, and I think the bottom line here is, are the people in business for themselves? Who's in control? Are they going to make money off of it? Are you going to make money off of it?
And a couple of red flags. We're going to jump ahead a little bit. Roberta's going to close with some suggestions on self-auditing to see if you have some problems. But two things Roberta mentioned a moment ago that I want to stress. Real pitfalls. Number one, look at duration. If you're looking at somebody you've classified as an independent contractor and they've been working for you for 21 and a half years, that's a problem, okay?
See, you laugh, but I have gone to clients before and found where, they've been there 10 years, they just never really hired them. And you want to say, don't you think after 10 years you could decide whether that was really a necessary position? Yeah. But
I'm still a contract employee for McAfee Taft. I have not satisfied the orientation period. The other example that Roberta mentioned that's another red flag, if you have people working side by side, shoulder to shoulder, doing the same thing, I think that's really dangerous when one is an independent contractor and one's an employee. What about the former employee that converts? What can you tell us a little bit about what you've seen there?
That's a bit of a problem, too, for really a couple reasons. We'll get into the retirement plan issue, but you've had an employee, the person retires, quits, or leaves, comes back as an independent contractor. You have all sorts of issues. They came back to do exactly what they were doing, so of course they have a very good argument that they're an employee. And they also have an argument that they should still be, if they retired, or even if they didn't, that they should be covered by your retirement plan. And that's a liability that most people don't see coming. So that is a problem.
I had a call yesterday in which an employer was talking about, hey, I've got this long-term employee ending their employment, and I want to put together a severance package. It's voluntary, they're all on board, and I want to reward them with an ongoing consulting agreement. And as he described this to me, the day after retirement looked very much like the day before retirement as a consultant.
So best practice, if you really need those people back, have some space between the time they leave and they come back. Because I don't want to leave the impression that having independent contractors is evil. As Charlie started out, there are some good business reasons for it, but it is a real pitfall, and we can't emphasize enough, I think some earlier speakers did also, that the government really does care about this, and they really are funding this issue. I mean, the We Can Help on the Department of Labor's webpage, it's a serious issue to look at. And I also read an article that said in a survey of business leaders of the employment issues they were concerned with, this routinely came up near the bottom. So as HR folk, you may have a hard time convincing management that this is something to take seriously, but there are some real dollars here, and it is something, and we explain here a bit about.
Yeah, and it's coming about and brought to your attention in a couple of ways. We talked about the increase in enforcement by the Department of Labor, the IRS. You've got that in your material, and that's one reason you get a knock on your door or an email or a letter from the government. The other thing that triggers this is a disgruntled former independent contractor, okay? Suddenly, they didn't get the job they thought they were going to get, the regular job, or they didn't get the raise, or they just feel like they're disregarded. That's the individual that makes contact, I think, with the Department of Labor, the IRS, and starts the ball rolling.
It can come up, too, when an employee files for unemployment only to learn they aren't really an employee, or they file a workers' comp claim only to learn they aren't really an employee. Well, at that point, you may have a problem because the Comp Court, the Tax Commission, and the Oklahoma Employment Security Commission are all sharing this information. So were they to hire a lawyer for their comp claim only to find out they were never employed by you, that lawyer may say, well, there are other issues here. You, in fact, may have a lawsuit against them. So there are a lot of ways it can come up.
And one of the news phenomena that Curtis and Nathan mentioned in the context of OSHA is this whole idea of shared information and shared databases. We've got our Oklahoma Unemployment Workers' Compensation, the Oklahoma Tax Commission. They're sharing information. When one of them finds out that an employer is classifying an individual as an independent contractor, when in truth they are an employee or should have been treated as an employee, they're ratting you out to the other two agencies, okay? If that comes to light in a workers' compensation claim, don't be surprised if shortly on the heels of that order, finding that they're your employee, not an independent contractor, or an Oklahoma Employment Security Commission finding they're your employee, you got to pay unemployment, you get a call from the other agencies, the tax commissioner, I think, and we've even seen some instances in which federal agencies are sharing with state agencies.
Yes, absolutely. So what's the liability here? Charlie's going to talk about that.
Okay, the liability, we've really talked a lot about it. If you're in one of the incentives to treat somebody as an independent contractor is the avoidance of some expenses or some headaches. Unemployment, you haven't been withholding unemployment for that individual. You haven't had them covered by workers' compensation coverage, whatever that's going to look like here in the future. You haven't been withholding taxes, FICA, you name it. Roberta's going to hit hard, and this is a big money issue that sometimes gets lost in the shuffle, is I haven't been included in your benefits or retirement plan, and Roberta's going to come back on the dollar sign there, or I haven't been getting overtime. Independent contractors aren't entitled to overtime. If you've been classifying me as an independent contractor and not paying me overtime, and I'm determined to be an employee, I should have been getting time and a half all this time. And how are your records going to look if you've been treating me as an independent contractor? Maybe sketchy. The other thing we've run into, a lot of these laws only apply to employers of a certain size. I'll give you an example of something that happened about 6 months ago with us and a client we were working with, talking to the client about a medical leave issue. And I was out in their plant. And so I started asking questions about FMLA and dealing with this particular issue. And she says, oh, it's not a problem. We don't have 50 employees. We only have 35 employees. And I said, boy, I walked through your parking lot, and I've been through your office. It looks like you got more than 35 employees. And she says, well, yeah, we have 47 independent contractors, okay? So guess what? If any of those, all you need are 15 of those misclassified, and you should have been under FMLA all along. We're not going to go through this slide as your material. It's just kind of a laundry list of the tax liabilities. If you have been, we've talked about unemployment, workers' compensation, inclusion in benefit plans that Roberta's going to hit, but we also have a litany of tax liability and tax penalties under both federal and tax law if an agency determines someone you've been treating as an independent contractor is in fact an employee.
Charlie touched on the liability issue. I don't want to leave without mentioning this, but I've defended clients that got sued by the temp, under Title VII for race discrimination, age discrimination, and, you think it would be an easy defense to say they're not my employee, and it's not so easy. The courts use what's called a joint employer test, and so you would think that they worked for you or the temp agency, and it's just not that simple when you get to court. I've actually defended those cases, and it wasn't as easy as I wanted it to be. So don't think that you're off the hook just because you have a temp agency supplying these people from getting sued for some of these federal statutes.
And I was counting on it being okay to harass independent contractors. You're really taking the fun out of it, okay?
Yes, I actually had a vice president once ask me, a manager was accused of harassing a temp, and the vice president said, well, she's a temp, how can that be a problem? To which I said, do you think it's open season on temps? So the laws still apply in many, many cases. I think this is one of the biggest liability pitfalls is the retirement plan. The Microsoft case has been around for maybe a decade, but it's really one of the best cases. What happened to Microsoft is they had a lot of temp employees, independent contractors or so they thought, but they actually gave them an interest in the stock option plan, which I thought was kind of crazy and may have been their downfall. What happened was these people sued and said, we think we're really employees and we should be covered by your retirement plan. And the court agreed. And not only did the court agree, but it covered tons of employees back to the time that they started, not just on a go-forward basis, but they went backwards to cover these employees. So you're talking some huge liabilities. And so one of the things we're going to recommend that you do is that you look at your retirement plan, because you want to include what ERISA lawyers or benefits lawyers call the Microsoft language. What you do is you say, this plan is, I'm going to paraphrase because it's not an area where I practice, but you'll understand what I'm saying. This plan is intended to cover employees or independent contractors from the time they are declared employees. So it's a prospective only. You're not going back 5 years, 10 years and picking up these people. And then you need to change under the plan also the definition of employee, not to include independent contractors, but to include independent contractors once they have been deemed or declared your employees. Another plan issue that's a problem is the qualification issue. And you're going to hear from a lot of good ERISA lawyers this afternoon that can help you with this issue. It's not my specialty, but I did learn some of these things the hard way. If you have an ERISA plan, it's a qualified plan. Your company may be making contributions every year of $10 million, $20 million to cover the employees. And I promise you, your finance people are counting on getting a tax deduction for those contributions. Well, the plan may lose its qualified status if you cover people you should not cover, or if you don't cover people that you should cover. So I don't think anybody wants to be in a position of telling a CFO or the CEO, God forbid, that you've just made a $25 million contribution to your plan and you're not going to get a deduction for it, and you're going to have to cover people that you didn't intend. So I think the retirement issues are big issues, and would encourage all of you to seriously look at your retirement plans or have the appropriate person do it.
Yeah, and there's a big dollar sign attached to that, as Roberta said. Our emphasis, if you couldn't tell from the title, Government Gone Wild, is what we want to do is we want to give you as much information as possible for you to go back and see if you have problems and solve them in advance. We want the Department of Labor and the Tax Commission and the Workers' Comp, we want them to pay attention to other folks, okay? So, enforcement targets, okay? The federal agencies, the Department of Labor, the EEOC, the IRS, they have made no secret of who they're targeting. And they target businesses and industries they think, when it comes to misclassification of individuals as independent contractors, when they are in fact employees, they've targeted the ones they think have the most misuse. And they've told us, hey, here's who we're going to be looking at, okay? And guess what? The states, including Oklahoma, says, you know, that looks like a pretty good list for us too. So when we're looking at misclassification of individuals as independent contractors instead of employees for purposes of workers' compensation, for purposes of unemployment, for purposes of overtime, for purposes of state tax, we're going to use the same list the government is. So here you are, okay? In no particular order, the fickle finger of fate: construction, janitorial or maintenance, home health care, child care, transportation and warehousing, meat and poultry, and professional and personal services. Now, that doesn't mean if you don't see your business or your industry listed, you're out of the woods, okay? Because, again, we see this rise more often than not from an individually disgruntled employee, former employee, contractor, former contractor. Guess who else is ratting out employers? Unions. Unions. Even if you're a non-union employer, unions hate independent contractors because they can't organize them. They can't make them pay dues. So if they see a profitable, flourishing employer that has a lot of independent contractors, there are no lack of avenues for them to contact the Department of Labor, Wage and Hour Division, you name it. There is a cottage industry now of 800 numbers on all the websites. Go to DOL.gov. Look at We Can Help. If that isn't a mechanism to beat the bushes for lawsuits, I don't know what is. Anybody see the articles last 6 months about Darden restaurants? Darden restaurants. That's Olive Garden, Red Lobster, and something I can't remember, like maybe it's Longhorn Steakhouse or something like that. Go Google that and find the website for the law firm that is soliciting plaintiffs. And what happens is, if a law firm discovers there is an employer who has a practice of misclassifying individuals as independent contractors or employees, if they can get enough of them, that's very lucrative. And they will go out and solicit. They'll get names from other individuals. They'll set up a Facebook page. They'll set up a website. And that makes it very, very profitable for plaintiffs' lawyers. So we're seeing a lot of that sort of solicitation and development of new lawsuits on misclassification, not just through the government, but through private employers.
So what can you do? Well, oftentimes these employees don't come through you. Sometimes they do, but at some companies they come through procurement or supply chain. So the first thing you have to do is figure out where these people are, how many you have, what they're doing, how long they've been there. I mean, you need to take it upon yourselves, if you possibly can, get management to buy into that project and figure out where these people are and what they're doing, how long they've been there. I mean, that's a place to start. How are they being paid? You know, are they getting W-2s? Are they getting 1099s from you? Are they being paid by a separate entity? You know, until you go find them and figure out how long they've been there, what exactly they're doing, and hopefully you won't have the situation where they're side by side with somebody else that they've been doing the exact same thing. And then you got to revise your retirement plan. I think that's perhaps the most important thing. If you don't leave here with anything else, I think that's where some huge liability lies, and it's important to do that.
You know, the audit Roberta's talking about, once you start digging into that information, you get a pretty good picture of what's going on. As Roberta said, find out where you're spending that money, find out where you've classified individuals an independent contractor, and follow that string and see if you have some of the red flags that we're talking about. If you do, this is your chance to identify them and solve them. Don't wait till the knock on the door. Don't wait till the phone call from the agency. Wanted to thank you for coming this morning's sessions. Hope you come back, and Roberta has some housekeeping tips.
No, just don't leave any stuff here because there might be people in here. The afternoon session starts at 1:30.
Yeah, there's a lot. Don't leave anything unattended. There are a lot of lawyers around
And
here.
there's
Okay?
there's a list of restaurants out at the registration table if you're not sure where to go.
Thank you.